Thank you, my Lord, for giving me the opportunity. My Lord, first of all, I want to make some submissions on something which appears very, very minor, but the applicant petitioner has made it as a legal question. So I have to clarify. My Lord, look at the pleadings. They have sued the county government of Nyandarua. They have, and second respondent, Moses Dirangu Badilisha, who is the governor. My Lord, they have not sued the county executive or the county assembly separately. They have sued the county government. So, my Lord, that question has a constitutional implication. My Lord, what is the definition of a county government in accordance with the provisions of the Constitution? My Lord, that takes you to Article 176(1) of the Constitution, which says there shall be a county government for each county consisting of a county assembly and a county executive. So, my Lord, at base, from their complaint in the petition, they are saying that there was no public participation by the county government. So, inevitably, it means that they are also complaining that there was no public participation by the county assembly. So, my Lord, the question is there any public participation from the county government side? That is the question which, my Lord, you've been confronting when determining this issue. And, my Lord, shortly I will be making submissions that indeed there was public participation. So, my Lord, they cannot come to court and say, no. The county assembly has done public participation. The county executive has not done public participation. My Lord, that submission, with a lot of respect, is a little bit contradictory and preposterous. My Lord, secondly, there is a principle in law which is basic, my Lord, and my Lord, allow me again to make some submissions on it, that, my Lord, parties are bound by their pleadings. A petition cannot be, and a complaint cannot be a moving target. Initially, my Lord, when they filed the notice of motion, they said there was a bill. They wanted to challenge the county finance bill, which they said no public participation had been done. My Lord, we told them that there's actually an act of the county government which has been published in accordance with the normal procedures. And, my Lord, they now have amended their motion. But, my Lord, you need to look at the grounds of the motion and the supporting affidavit. What is the principal complaint? My Lord, is the principal complaint about the economics, adequacy, or otherwise of these charges? My Lord, the principal complaint is that if you look at the grounds in the motion, and my Lord, the petitions are bound by this. They are saying that there was no form of public participation at all. That is their complaint. So, my Lord, where does that take us? If you say there was no public participation at all by the county government, then it means, from a constitutional standpoint, Article 10, my Lord, there is a big problem if there was no public participation. My Lord, Article 10 provides public participation as one of the most fundamental principles of governance. It binds all state organs, including the county government. And, my Lord, specifically, there is an obligation under Article 196 of the Constitution, which says a county assembly shall facilitate public participation in the business and affairs of the assembly and its committee. So, my Lord, let us determine that factual question first before we go into the other issues about the adequacy, which I will respond to. My Lord, it is not true that there was no public participation. My Lord, remember that the county finance bill is a bill which is enacted every year. It's not enacted in a vacuum. And therefore, it will contain that the finance bill or act will contain references to charges for the previous year. And then the proposals for this new year. My Lord, the county government is then duty bound, whether it's through the county executive or the county assembly, before this instrument is finally enacted into law, to undertake public participation. So, my Lord, contrary to the submissions by the petitioners that there was no public participation, my Lord, I want to invite you to look at the annexures. My Lord, look at the first annexure, my Lord. My Lord, the first annexure. Annexure number MK1. My Lord, it's at page 7 of our bundle.
Yes.
My Lord, what do you see there?
MK1.
Yes, my Lord.
MK1?
007, my Lord. Annexure number MK1. It is 007.
Bill 2022 public participation.
Yes, my Lord. My Lord, this is a notice which was put in the newspaper. My Lord, it was put in the website. My Lord, it was put in all the public forums for everyone to look at by the county assembly. My Lord, it was very easy for the county executive to develop proposals. My Lord, remember that proposals, my Lord, which come from the county executive are not binding, my Lord. They are not binding to the county assembly. The county assembly will at the end of the day conduct meaningful and qualitative public participation, which, my Lord, I have submitted as a constitutional bearing. So, my Lord, you can see there is a public notice. My Lord, there is a public notice addressed to everyone. It says, and my Lord, this is the extract which we got from the website, and it is there in the newspapers. They are not disputing this. My Lord, you can see, it says, notice to general public of the Nyandarua County on the Finance Bill 2022 public participation exercise. And my Lord, we have listed places where the public participation was going to be undertaken. My Lord, the question is, my Lord, must we conduct public participation in all the wards, all the villages, all the houses? Must we conduct public participation in all the marketplaces within the county government? No, my Lord. My Lord, we are required to simply designate a place and ensure this information reaches out to the people. And my Lord, that's what we did. My Lord, did the people show up? My Lord, if you look at page 9 onwards,
Yes.
I have printed photographs of the actual public participation meetings. My Lord, if you look at where the people are giving views. My Lord, if you look at page 9, page 10, page 11, page 12, page 13, 14, my Lord, all the way to 21, at least I have made efforts for purposes of this honorable court evaluating the threshold of grant of conservatory orders in the case of Peter Gatirau Munya, one of the well-known cases on the test of conservatory orders. For that purpose, my Lord, we have annexed evidence of actual public participation. My Lord, isn't this not enough to demonstrate that there was actual public participation? My Lord, if you look at page 22, I have gone ahead to be candid enough to say that these proposals which we put, some of them were opposed by the people. My Lord, if you look at, for example, on the question of ambulance charges, the people said you can't increase. So the question which I want, my Lord, to put into fore is that, was there a meaningful and qualitative public participation to, of necessity, meet the threshold in law as cited by my colleague, Mr. Ndegwa Ohome, based on the case of Robert Gakuru, which I argued in 2014? My Lord, yes. There is some meaningful and qualitative public participation. So that, my Lord, this honorable court can't just disregard what was done because the charges by in accordance with the petitioners, they say it is painful, there are harsh economic times. etc. My Lord, under the Constitution, these charges are raised on behalf of the people. They are not raised by a separate entity known as the county executive or county government. My Lord, Article 1 of the Constitution says this county government exercise sovereign authority on behalf of the people. My Lord, this money which is collected, it is supposed to be used to provide services to the people, my Lord. It's not, it is not money belonging to the governor or the speaker. It's money for the people. And my Lord, that is very important because my colleague, Mr. Home, has submitted as if the county government exists separate from the people. It just collects revenue and disappears, spends. My Lord, it spends this revenue for the people. My Lord, let me come now to the most important document, which leaves it no doubt whatsoever, my Lord. My Lord, it leaves no doubt whatsoever. Because, my Lord, I really wanted to annex this document. That's why yesterday I really had to ensure the county assembly gives me the document. My Lord, look at page 025. The report of the county assembly, my Lord, on the public participation. My Lord, it runs all the way from page 025 to page 160. My Lord, there is one thing that I want to explain just by way of introduction on this report. My Lord, despite the public public notice which was issued, and my Lord, this is now something which will have a bearing on on the petitioner's case. My Lord, this report says they never received any written memorandum from anyone in the county government. My Lord, we issued a public notice, we undertook the meetings, but my Lord, we never received any written memorandum from anyone, my Lord, apart from the views that we got from the meetings that we held. So my Lord, that tells you very much that public participation, my Lord, does not mean that we have to sit and consult every citizen. My Lord, there is no law that binds the county assembly as an entity of the county government from compulsorily collecting views from the people. My Lord, the granting of views is a voluntary exercise. My Lord, if it is out there in the public domain, and my Lord, if you don't participate in the affairs of government, you don't come out, then later on you complain. My Lord, these people have not participated in the affairs of this county government, the petitioners. They're just coming out to complain, my Lord. But my Lord, this report is comprehensive enough. It gives additional, my Lord, when you retire, you'll have opportunity to look at it. My Lord, it gives additional details. And my Lord, of necessity, I will request that you look at page 107 of that report. Page 107, my Lord.
Page?
107.
Yes.
My Lord, you will see additional photographs attached to the report. 107 down there, you will see, my Lord, the additional photographs. My Lord, page 107 of the report. Is it paginated, my Lord, down there? Of that report.
But they seem not to have those photos. The photographs I'm seeing are from
yes.
103.
Yes, my Lord. Yeah, that is the report, my Lord. My Lord, you will see that yes. Apart from the photographs you annexed earlier, these are additional photographs of the county assembly engaging with the people. So, my Lord, our submission is that there was meaningful and qualitative public participation to the persons who are interested in the process. The ones who showed up, we engaged them and we had a candid discussion. My Lord, my colleague seems to be making heavy weather about memorandum to the governor. My Lord, in the normal law-making process, my Lord, in the normal law-making process, a bill will be passed by the county assembly and then taken to the governor for assent. My Lord, the provisions of the County Government Act provide that the county governor can return the bill with his comments. My Lord, the county governor exercise sovereign authority on behalf of the people. If there are issues which the county governor wants addressed, my Lord, the county governor will go ahead and say, hey, county assembly, please, can you address issue number 1, 2, 3, and 4? My Lord, that's what he did. And my Lord, if you look at page 110, you will see the report which is the county assembly considered the memorandum of the governor on the finance bill. My Lord, they considered, my Lord, of this memorandum. And my Lord, they took on board his views. And my Lord, they eventually passed a finance act, which is at page 170. And my Lord, this is important because I want to make reference to the Constitution. Page 170, my Lord, you will now see the Finance Act, which was passed on to that legislative process. My Lord, this Finance Act, on the face of it, is gazetted. It's at page 170. Down there, it's page 169, but 161. But up here is page 170. I think we did second pagination. The one done physically, my Lord. You will see the actual Finance Act. This is the demon, my Lord, which my colleague is trying to face. And he's saying, my Lord, it's unconstitutional because there was no public participation.
The one I have will start from page 157.
Yeah, I think, my Lord, there's something about pagination.
Yeah.
Yes, but my Lord, at least, my Lord, we have annexed the Finance Act. You will see that on the face of it.
Yeah, I'm seeing it.
Yes, my Lord, it is gazetted. Special issue in the Kenya Gazette.
Yes.
So, my Lord, I wanted to mention something which is very significant for our purposes. My Lord, in the grounds of this motion, the petitioner says that there is no basis for these additional charges. My Lord, that's what they have said.
Yes.
My Lord, first of all, let me make this clear, that without a legislation, the provisions of the Constitution will have been violated. My Lord, under the provisions of Article 209, 210, more importantly, 210(1), it says, no tax, licensing fee may imposed, waived, or varied except as provided for by legislation. So, my Lord, there is constitutional compliance that we have a legislation provide the basis of any charge which the county government is levying. And my Lord, in one of the items in the I'll just make reference to one of the items because I believe I don't want to go into all the details. My Lord, in one of the bases, they are saying that we have increased charges from 29,000 to 40,000. And they're saying, oh, this is oppressive, that there is hardship, there is COVID, that the court takes judicial notice of the hard economic times. My Lord, have these petitioners produced evidence in court with respect to their income statements for you to see what they are making? Income. For them to complain that it's oppressive. My Lord, the timber industry is one of the most lucrative subsectors in Nyandarua County. Then they are saying there's a cartel. My Lord, they don't want to pay an additional 11,000 from 29,000, which they have been paying all along. Then we increase it to 40 because of obvious reasons. And then they come to court and say, we don't want to pay that. We want to pay 29. My Lord, this takes me to a fundamental legal issue, which I will invite you to determine. My Lord, the question of the adequacy of the amount in the Finance Act. The question of the quantum, the figures. When you increase it from 1,000 to 2,000, or from 29,000 to 40,000. My Lord, is this court competent enough to audit that increase? My Lord, is in that not where we now draw the line and we ask the court to put down its pen because of the application of the doctrine of separation of powers. My Lord, this increase is for legitimate county government purpose. So, my Lord, based on the case of Muma Matemu, Court of Appeal decision, my Lord, we are submitting that when you apply the rational basis test to evaluate the decision of the county executive or the county government, my Lord, to increase this revenue, my Lord, you do so in a manner that respects the principle of separation of powers. My Lord, what I'm saying is that it's only the county government which is competent enough to determine the question of the increase of this revenue. My Lord, this honorable court has no evidence, and none has been provided to court. My Lord, the fact that there are harsh economic times is not a reason for the county government not to increase revenue in a lucrative sector like the timber industry. So, my Lord, I don't understand the petitioner's complaint when they come and to court and say that it is punitive and harsh. We have just increased it by 11,000. So, my Lord, in summary, I submit that the questions concerning the quantum of taxation are matters which are highly polycentric. They are within the province of policy. They require a balancing act. That is why, my Lord, that is why, and my Lord, when you retire, you look at the Finance Act. You look at the charges which we have outlined in the Act, you will see we have not touched some charges, and while others have been increased. So, my Lord, there's a policy rationale for that increase, which I submit is not the province of the court. Because if, my Lord, that were the case, then we will go item by item. Then we will provide some kind of an econometric analysis of these charges and a justification, which, my Lord, they are inviting you to do. So, my Lord, on what basis, let me ask, on what basis are they saying that you determine that 29,000 is sufficient and 40,000 is not sufficient? On what basis? On what legal basis conceivably known under the sun? Because the question of public participation, my Lord, we have addressed it. That's not a basis. Because, my Lord, I admit, if there was no public participation, my Lord, if there was no public participation, then we will have breached the Constitution. So, to the extent that there was meaningful and qualitative public participation, that question is settled. The dispute is rested. So, let's now come to the next level question. The next level question is that the increase is unconscionable. They said punitive. They said arbitrary. My Lord, is that the case? From the evidence that I've seen in this replying affidavit, my Lord, that is not the case, my Lord. Lastly, my Lord, I will want to buttress my point by looking at annexure number MK6 as I make my last submission. My Lord, MK6 contains a document known as the citizen budget, a summary of the citizen budget. My Lord, it contains, this document contains how the summary of information of how the people of Nyandarua are going to spend their money through the county government in terms of allocations. And my Lord, you can see here we are dealing with figures. There is the equitable share from national government. And my Lord, I will invite you to look at page 255, the question of county expenditure. My Lord, in summary, the county government has done a budget where it anticipates to collect certain revenue from the people and businesses to provide services to the people. That's what this budget says. My Lord, there is revenue which it seeks to collect from local resources, not from the equitable share. So, my Lord, if you make a determination to suspend the revenue which the county government has proposed to raise, there will be a direct interference on actual expenditure. The budget making process and actual expenditure. And that interference, my Lord, will be then the breach of the doctrine of separation of powers. My Lord, it means from the money which the county government has proposed to spend on water, environment, hospitals, some of which is equitable share and some of which is local revenue. My Lord, there is a possibility that the county government will be unable then, for example, to buy medicine or to build a particular road because of a conservatory order which was granted, stopping the county government from collecting revenue, the way my colleague is requesting. So, my Lord, my submission on that point is that conservatory orders which the petitioner is seeking will have far-reaching implications on the budget-making process. My Lord, now that the petitioners are in court, let me be pragmatic, and my Lord, maybe you can make this a finding. My Lord, now that the petitioners are in court,
Yes.
they are aware that there's a Finance Act. Initially, they never responded to the public notice. They never attended our meetings. My Lord, not a single meeting they showed up or asked my colleague Ndegba Home to represent them to raise all these costs. They never showed up. And my Lord, because we are dealing with the Finance Act, an act can be amended. There is room for the petitioners to now engage the county government if they think that this is a process which they need to participate this late. My Lord, they can engage the county government. It's not too late in the day. Through the appropriate channels, they can petition the county assembly. And my Lord, if there is need for any consideration of any charge, my Lord, an appropriate amendment will be made to the act. My Lord, this act is not cast in stone. It can always be amended. What, my Lord, we can't do is stop its implementation through a conservatory order. My Lord, they can come to us. We will ask for books of accounts to see how much money they are making from the timber industry. We will examine the challenges which they face. And my Lord, if need be, we will make appropriate proposals to amend the Finance Act. Maybe the charges will be increased from 29 to 35,000. Or maybe they'll be increased to 50,000 from 29. We never know. So, my Lord, my submission is that there is room for engagement with the county assembly. My Lord, the county assembly represents the people at that local level of devolution. So, my Lord, absence, breach of the Constitution, the requirement of public participation. My Lord, that will be the only option, my Lord, which we can have. So, my Lord, in summary, and my Lord, sorry, there's last issue, my Lord, which my colleague submitted, the county revenue administration policy. My Lord, county governments operate through policy instruments. My Lord, these policy instruments crystallize aspirations of the county government at any point in time. So as we speak, my Lord, the county government has a conceptually satisfying county revenue administration policy, which was not set for this purpose. It was set for the broader revenue administration policy in accordance with the best practices in legislative development and implementation. So, my Lord, it guides the development of any policy on revenue. So, my Lord, going forward, because it was adopted eventually on 23rd February, my Lord, going forward, we hope that this honorable court will not be swung with disputes about revenue and all that, because we want to increase the level of engagement with all the stakeholders so that we minimize disputes. So, my Lord, with that, I conclude my submission by saying that, my Lord, when granting the conservatory orders to suspend an act of parliament, in this case, an act of the county government, the threshold is in the Peter Munya case, the Supreme Court finding. My Lord, to the extent that my colleague has made submissions on behalf of the petition that there was no public participation, and my Lord, we have seen some public participation, then the first threshold has not been met. So my Lord, I urge that you exercise restraint and not suspend the act. Thank you, my Lord, for listening to me. I think, my Lord, I have taken 27 minutes. Thank you, my Lord. Thank you very much.
Yes.
Thank
Mr.
you.
Wahome?